Hello IP friends, welcome to hashtag IP series with Reader. So for my new listeners, thank you guys so much for listening to my podcast. I really do appreciate it. Don't forget to favorite and subscribe so you don't miss out on any episode. As for my returning listeners, you guys are the best. Thank you for sticking by me. It's 1 year already and 2 months, but you guys are always coming back listening to my podcast. It means I must be doing something really good. But if I'm not, don't forget to send us an email so I can improve. ipseriesInfo@gmail.com is the email, or you can send us a DM on Facebook, Twitter, LinkedIn, and Instagram. So basically what we do here is talk on recent intellectual property cases that are trending within Nigeria, in Africa, and globally. This could be in form of copyright, trademark, patent, industrial design, trade secret, geographical indication, and plant variety. So let's get into today's episode. Okay guys, so have you ever seen, say, a picture or listen to a song and you heard some lyrics or compositions or sound recording that really sounded similar to the one created by a deceased IP owner? If you have, let me know, either by commenting on any of the platform you find my podcast, or just send me a voice note on Anchor and I'll definitely listen to it, or do us an email. And we know that when it comes to IP, consent, permission, authorization is very important. And where an instance where the IP owner is deceased, his or her heirs have the right to exercise whatever exclusive rights that were reserved for the deceased IP owner. So they are more or less benefiting from the work that the deceased person has put while they were alive. And we know the term of duration differs from the form of IP, the various form of IP, whether it's copyright, trademark, patent. So if you've seen something and you're like, you could link it to someone that was later, like, this thing actually belongs to this person. So today our conversation will focus on how the heirs and successors of a deceased IP owner can commercialize the intellectual property rights they have inherited. And our case study for today is a rather interesting one. I hope you guys like it. I've done a podcast, a Twitter version. This is a podcast version. I might do the newsletter. Fingers crossed. If you want the newsletter, please let me know as well. So let's get into our case study for today. So sometime in May 2021, the All Progressive Congress Party, which is one of the most political parties in Nigeria, created they did create a shirt bearing JAGABAN, but used the name FELA KUTI beneath. That's down the down part of the shirt. And Femi Kuti took to his Twitter page, putting up a notice that the political party was never authorized to use the name FELA KUTI, which I found really interesting, because it's rare to see heirs, especially in Nigeria, being proactive about what the deceased IP owners had left for them. So it was really nice to see that. But then the Kuti family has always been proactive when it comes to protecting what was left to them. And so on today's episode, I'll be talking about the intellectual property rights of a deceased IP owner, how it can be enforced, exploited, and commercialized by their heirs and successors. First thing first, you must be vigilant or proactive when it comes to protecting the work of a deceased IP owner, so that it doesn't get abused, especially within Nigeria, where anyone will just wake up and use something and they're like, oh, you should feel privileged that I'm giving you publicity or making you popular. All those conversations that they shy away from, taking responsibility of being diligent and doing the right thing. I know that CPA is very important. You need to clear the right to use that work in question. Under section 12 sub 3 of the Nigerian Copyright Act, it states that an author will include his heirs and successors in title, and they have the right to claim authorship, while subsection 5 says that they also have the right to share in the proceeds of the sale. So if the work in question is sold, they have the right to also benefit by getting their own share of the sale. Subsection 2 of section 13 also provides that an author has the right to claim authorship of his work in connection with the exclusive right listed in section 6, which is selling, licensing, performing to the public, distributing to the public, whether it's a literary, artistic, musical, cinematography, or sound recording. And these are rights that are only exclusive to an IP owner in this case. As a creative person, when you are thinking of intellectual property as an intangible asset, see it as a long-term goal for you, that even if or when you die, your heirs and successors can also benefit from the work you've created. Now, how can your heirs and successors enjoy the intellectual property rights they have inherited? It also depends on its form of IP, whether it's copyright, trademark, patent. For copyright is the lifetime, so the duration of how long you've lived plus after 70 years after you've died. So your generations, let's say your first 2 or first 3 generations, will benefit from the work that you've created. Now, as a third party, if you also wish to use the work of the dead, you have to do your due diligence by reaching out to the family, clear and get the IP rights to use the work in question. So if you're doing a movie, you want to create a film about, say, Fela in this case, now you have to reach out to the Fela Kuti's family and obtain the rights to do a story about a movie about Fela Kuti. If it's a sound recording or composition, get the rights from the family to sync it into your film or your song or whatever it is you're doing. And in some part of the US, the IP rights of the deceased comes with various options of protection. This will also depend on the territory or jurisdiction or county that the deceased IP owner was residing or living in. So in order for your heirs and successors to monetize this IP and also exploit your right of publicity, they must work hand in hand with their lawyer versed in intellectual property, estate planning, and probate. That's the wills and wills. They'll be bound by the laws of that state where the person died and was resident. So ways you can commercialize the IP rights of a deceased author: you can opt for an exclusive or non-exclusive license, whereby for an exclusive license it's just between you and one person, but for non-exclusive you can give the license to several persons to use the work in question for whatever it is they want to use, but it has to be with your consent. You also have to be proactive in protecting the name and likeness of the deceased author from infringers. Like in this Fela's case, now Fela had to ask them to cease and desist from associating themselves with Fela Kuti because they had not given them the right to use the name Fela Kuti. So one case that stood out for me was the Bruce Lee family, Bruce Lee Enterprise. So they had sued a fast food chain called Real Kung Fu over the use of an image of Bruce Lee without their consent, permission, or authorization. And they were suing or asking that they pay them $30 million in compensation. The case hasn't ended. Don't know how it is, but I will be looking out for that. Another thing is that IP owners can explore trademarking the name or creating a merchandise or exploring the rights of publicity as a celebrity through image rights, commercializing the intangible assets. So you also need to look at the laws within your jurisdiction to be able to do all of these I've mentioned. Even if you don't have laws guiding you per se, talk to your lawyer, your IP lawyer, and come up with a strategy on how to keep benefiting from the intellectual property rights that you have inherited. I hope this made a lot of sense to you guys. And so on to the next IP series. Keep streaming and playing my podcast. Subscribe. Send us an email if you have any case interested in that you would want us to talk about to ipseriesinfo@gmail.com. Follow us on all social media handles. And yeah, see you in the next episode.